my lawyer need me to sign an engagement letter? In most jurisdictions, a formal engagement letter is required to establish the attorney-client relationship. Just because you have a helpful consultation call with a prospective attorney does not mean that person is now your lawyer. Or just because you meet an attorney at a dinner party or at the bar and they make some general comments about a legal question you're facing does not make them your attorney. And I'm betting they probably said so to you explicitly before making any meaningful remarks. If you're venting and blabbing about a crummy legal situation and expecting your comments to be privileged just because they're being said in the presence of somebody who happens to be a lawyer, please take a beat. Privilege generally doesn't adhere unless and until the attorney-client relationship is established, and a written engagement letter memorializes that. Hopefully you've seen the notices I put at the end of each video and on my social media and websites and elsewhere. Although I truly hope that the general information and education I provide in these videos and posts is useful to you, I am absolutely not your attorney, and I won't be unless and until I send you an engagement letter and you sign it. Much like the dinner party and barstool scenarios, I'm a lawyer, but I'm not your lawyer. And this is a public forum, so please don't ever post anything you want to remain privileged or confidential in the comments. Similarly, sending me or another attorney a DM won't establish the attorney-client relationship or create privilege. Our assistants generally screen these messages, or they might not even be read at all. If you want to engage a lawyer, go through that firm's standard intake process, typically through their official website or by telephone. As far as the engagement letters themselves, I know they can be lengthy, but they're intended to protect both you and your lawyer and to prevent any future misunderstandings. Me saying, oh yeah, it's for your own good, isn't just posturing either. The engagement letter really should help you to better understand your rights as a client and the lawyer's obligations to you, both while the representation is in effect and to a limited extent after it's been concluded. Here are a few things to look for in your engagement letter. First, scope of services. This will be a general description of the nature of the work the lawyer will perform for you. Something like creation of an employee policy manual and advice and guidance for company employment matters, or drafting of an operating agreement, form of MSA, and other commercial contracts, and business law advice is mutually agreed from time to time. Next is the fee structure. This is where your lawyer indicates whether billing is done on a flat fee, contingency, or billable hour basis, provides information on rates and other charges, and sets forth other financial information. Usually this is the part that clients care about the most. Next, retainer requirements. If your lawyer requires a retainer deposit, the engagement letter will include information about the amount, the bank and trust account in which your money is held, policies around re-upping the retainer, and more. Please check out some of my earlier videos on retainer deposits for additional details. Next, firm policies. The law firm may elect to include certain of its policies and procedures regarding anything from finance charges on overdue balances to payment methods, record retention, periodic rate increases, and more. There's also conflicts of interest and joint representation disclosures. If your lawyer jointly represents you and your spouse, or you and your business partner, or you and any other third party, you can expect to see language regarding joint representation and conflicts of interests. Other circumstances could give rise to conflicts of interest language as well, which are out of scope of this video. If this language has been included in your engagement letter and you don't understand why, ask your lawyer about it. Finally, rights after termination of engagement. The letter should explain when and how the attorney-client relationship may be voluntarily terminated by either party, or perhaps how it may be terminated automatically, for example, upon the conclusion of a limited scope project or after a year has passed without any legal services being rendered. The letter may also explain your rights to recover your documents from the firm or how to have your files transferred to a successor law firm. Some of these terms will be governed by the rules of the applicable state bar association, but many of these terms can vary significantly from lawyer to lawyer, so it's important that you read and understand the engagement letter before you sign it. If you're confused about what it says, you can and should ask your lawyer to clarify. Or if a term is contrary to your expectations or is otherwise unacceptable, you may be able to negotiate it with the attorney. And once it's signed, please retain a copy in your records for future reference if needed. Business owners. Which elements of the engagement letters that you've signed are helpful and which are confusing, frustrating, or in need of improvement?